Good evening, everyone. Tonight is a meeting of the Planning Board of South Kingstown. It's a combined regular session and work session. The first item on the agenda is roll call. Susan Axelrod.
Here.
Joe Murphy. Here. Robin Pothier. Liz Carp. Caper Wilson.
Here.
And Peter DiStefano is absent, and Maria Mack is here. Before we begin, I'd like to advise folks who are here this evening on a couple of changes to the agenda. We will not be discussing the work session items, land use, Old Tower Hill Road, due to scheduling conflicts, update from Planning Department staff, unless Jamie has something that he feels is necessary, or update on legal issues. So other than the liaison activities portion of the work session, the remaining items will stay the same. Our next agenda item is approval of minutes. This includes minutes from the May 13th, 2025 meeting, May 29th, 2025 meeting, report of the administrative officer, which includes minor subdivision and land development projects, minor subdivision preliminary plan, change to previously approved plan, 64 Frank Ave, Industrial Park. If there are no corrections or additions, would someone like to make a motion to approve the consent agenda?
I have a few items we should address.
Go ahead, and then Liz.
On the minutes for May 13th, I'm sorry, I need to... At the end of the minutes, upon motion made by Mr. Murphy, duly seconded by, we don't have who the second is. We should either fill it in or at least say it was duly seconded. I recall it was duly seconded, but regrettably, my notes don't reflect by whom.
Someone with
Madam
lesser
Chair,
vocal skills.
We'll make that administrative correction.
Okay. Anything else?
On the May 29th meeting, on the third page, at the top of page 3, item number 3, talks about the most recent request extended through August 1, 2025, but as you'll see 2 paragraphs later, it was extended until August 1st, 2026, which is consistent with my notes from the meeting.
Again, Madam Chair, we'll
That can
check
be
the
corrected.
administrative side of that.
Yes. Anything else? Robin?
Same page, item number 4, where it states that Mr. Swartz also stated that the applicant could give a good enough reason why there is a hardship. I'm not sure what's implied by that. Is that using one's imagination, or did they give some reason that you considered good enough for hardship?
I think that's part of the process. Peter, do you want to?
Just that they,
The standards that are, yes, that are generally
just that they
required.
possibly could come up with something.
They're generally,
Those are the standards that we would have to meet.
Understood. I thought it implied that they had that. Okay.
But and the following sentence says that Mr. Swartz added that an ADU added to an existing structure must be granted by right regardless of the lot dimensions. I actually thought you qualified that by talking about of a certain lot size, but I'm not sure. I just wanted to make sure that you felt that this accurately reflected your statement.
If it's within an existing structure, then it is allowed by right, regardless of lot size.
So you're happy with the phrasing?
That's fine.
And then I simply wanted to notice under item number 5, the second paragraph, it says that Jamie's going to create a letter to be presented to the board at the next work session, and I didn't see that in my
I
packet.
asked him tonight, not yet completed.
Perfect, thank you.
I do ask him this on pretty much a weekly basis, so no worries there. Anything else?
Those were my only issues.
Would someone like to make a motion to approve the consent agenda items as amended?
I'll make that motion.
Motion from Capers, do we have a second? Second from Liz. Any further discussion? Hearing none, all those in favor say aye. 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 Motion passes unanimously. Next agenda item is a continued public hearing, major land development change to a previously approved conceptual master plan, 571 Main Street. We have a letter from the applicant, signed by Matt Landry, asking for a continuance to our August meeting. Jamie, can you give us the date of that?
Sorry, the date of the August meeting?
Yes.
Just give me a moment.
Okay. And Mr. Landry is here this evening, so.
Good evening, Madam Chair, members of the board, Attorney Matthew Landry on behalf of the applicant. I'll just provide a brief comment and an update. As you know, we've been working with DEM to try to review the updated plans that we presented, I think, back in April. The board had just recently approved a one-year extension to the master plan deadline last month. My colleague was here, and I appreciate that. Thank you very much for doing that. Since DEM went to the online permitting system, there was a blackout period for submitting these applications. And because of the seasonal construction timeline and everything else that's going on, we're really delayed by DEM, which is the need for these repeated extensions. We really can't proceed without DEM's blessing on this to make sure that everything is going to work. As well as verifying the wetland edges for the new location of the road. So that's the reason for the request. We're doing everything we can to push that along. And as of 2 weeks ago, Molly Titus at Dupree informed us that there was a discussion with DEM and an update is to be expected within the next 2 weeks. Where that stands, I'm not sure, but we anticipate submitting supplemental plans following that DEM update and their report. So planning staff can review it, can go to TRC and run its usual course. But that's the reason for the delay. I just want the board to be informed.
Great, thank you very much. Jamie, what's the date?
Sorry, the date, Madam Chair, is August 26th, Tuesday.
Okay,
So again, it would be appropriate to entertain a motion to continue the public hearing to
correct, to a date certain, yes.
date certain, place certain.
If no one has any questions, would someone like to make that motion?
I'll make that motion.
We have a motion from Caper. Do we have a second? Second from Joe. Any further discussion? Hearing none. All those in favor say aye. 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 Nays? Motion carries. Thank you. Next agenda item is a major land development project pre-application concept plan, Safe Harbor Marina. As board members are aware, pre-application meetings are general in nature, designed to be a sharing of information between the board and an applicant.
Again, thank you, Madam Chair, members of the board, Attorney Matthew Landry on behalf of the applicant, Safe Harbor Marina. Just as a housekeeping matter, I couldn't recall if you had an updated package with the architecturals. I had forwarded them to staff today to be viewed electronically. If not, I do have hard copies of those. Do you have
Is it this one?
architectural renderings? It is, and there was a series of conceptuals. If I may, I'll just hand out the
Certainly.
handouts that I have. They should be the same renderings that you have, and I will note that the very first picture that you see is not an architectural rendering. That is the existing building that is being demoed, so don't be alarmed when you see that first picture. And again, these are just for reference. I am joined by representatives from Safe Harbor Marina. Beck Bennett is the VP of Construction and Development for Safe Harbor. He can comment just briefly on the needs for the business and what the intended use of the new structure is going to be. Joined by Chris Fagan, who's the architect on the project, who can comment and provide some context on the conceptual renderings for that. And we also have Seth Lemoyne from Principi Engineering, who can speak as to the engineering aspects on the site plan. Again, this is a pre-app. We're at the infancy of this project. I think most of you are probably familiar with the Safe Harbor Marina there up in Pond Street. Safe Harbor Marina is a large organization that operates a number of marina facilities throughout the country. This one locally is owned and operated by them. And really the predominant need for this development application is to demolish the existing maintenance structure, metal warehouse building that's towards the north of the property that's used for maintenance operations in connection with the marina. It's about 2,400 square feet and is about 50 to 60 years old, as I understand it. And really, the marina has grown over the years and is a successful operation, and is really, that warehouse is antiquated compared to the needs that they have today, and really looking to upgrade the facility, make it modern, provide heating, additional bathroom facilities or upgraded bathroom facilities. As I understand it, Safe Harbor has to lay off a number of staff members in the winter because it's not winterized and they can't work in those conditions. So it's really in need of an upgrade aesthetically as well. This will be a significant improvement to what exists on the property. And I can have Beck and his team just comment briefly on what the intended use of that is, but it's used as a maintenance facility. It'll continue to be used as a maintenance facility, larger in size to accommodate the marina's needs, but will essentially be in the same footprint with the Slate expansion to that. In connection with this is an upgraded OWTS system for the property, so I think that is also a desirable result of this development. So OWTS will be upgraded. There'll be some surface improvements here. There's also some other site enhancements that are being considered, such as EV chargers and solar panels on the structure. Those are still being evaluated, but generally this will be a significant upgrade and improvement to what's there and help the marina facility and its customers. There are some preliminary discussions with CRMC. Those have all been favorable. We don't anticipate any issues with that. Marina uses, this is the CW zone. This is a permitted use. However, there is some boat storage in the winter season, and as I understand it, that's a use permitted by a special use permit. Regardless, this will fall under development plan review as we move through the process, and we'll be asking to proceed through that mechanism, and we'll abide by all those standards. Again, we don't anticipate any waivers or any substantial deviance from those regulations. This is also in two of the overlay districts, the Coastal Resource Overlay District and the Special Flood Hazard Zones. Again, I don't anticipate any issues with compliance with either of those if they are applicable to the commercial use. So the only change is really to the existing warehouse building. There's an existing office building, two-story office building and storefront that will remain. It's a little bit more modern. There's an existing pool and associated structure with that. Those are all to remain. So this is really limited just to the warehouse structure. Seth, do you want to just comment briefly on the OWTS and site design? And maybe if there's any technical questions as to that, Seth could probably be best equipped to answer that.
Good evening, Board. Seth Lemoyne from Principe Engineering, representing the client, Safe Harbors. The OWTS system was originally designed a few years back and permitted through DEM. However, that permit expired. We were tasked with redesigning that. A very similar system, bottomless sand filter. It's more or less the same footprint as it was originally approved. We've submitted our application to DEM once the portal opened back up after that blackout window, and we're waiting on response from them. We don't anticipate any issues with that. As far as stormwater controls go, we are meeting our water quality and infiltration requirements through a proposed bioretention pond to the west of the new structure. And we're reducing the storm rates and volumes for the 2, 10, and 100 year. I'll entertain any questions specific to those matters.
Questions from board members? Robin?
Sure. Could you help me understand better what you're doing for sea level rise? And I read that the building is 30 years old.
I think that structure was permitted in the early 70s, the facility that's being upgraded,
Okay.
the
well,
warehouse.
The letter says 30 years.
Okay.
Actually, it says over 30 years.
Big difference.
As far as sea level rise goes, we're not addressing those concerns specifically for sea level rise. We're keeping, we're in the base flood elevation for some portion of the site, and there will be no living spaces or bathroom facilities on the first floor of the new structure. The OWTS, like I said, is situated where it currently is located, being removed and filled, and we cannot realistically get out of the flood zone in that location, and nor are we allowed to fill in that location.
So do you have special storage for oil and fuels?
I'll defer to Beck on that, on his location of where he's going to be storing these chemicals and products. There are flood vents on that structure, correct? I'll repeat that. There's flood vents on the new structure to allow floodwaters to enter and recede out of that structure. There will be, yes.
Joe?
So it looks like a pretty significant improvement, so thank you for that. Questions for either now or when you come before us at development plan review, whether there's any changing in the lighting, either in the building or on the site now versus what you're proposing, especially any lighting that could be would be viewed by residential areas or the people traffic on the street, and then maybe the same with the outside storage, if there's any difference between now and proposed, and again, the concern being for anything that's viewable from the street or residential properties. But other than that, it looks like pretty straightforward and a nice improvement.
Thank you. As far as the lighting goes, I'm going to defer again to Beck on that. I was not involved in the site lighting, whether interior or exterior on the facility. And as far as boat storage goes, it's going to be very similar in nature to what it is today, with the exception on the west side of the building where our stormwater system is proposed. We are looking at an alternative system at this time, but that has not been reviewed in detail at this point.
The existing structure looks like it has quite a bit more glass than the proposed structure looks like it has quite a bit more glass than the existing structure. It's very aesthetically pleasing. In some of the projects that we've had, in particular marinas or waterfront, in the past, some of the neighboring properties was concerned about lighting levels in the evening or late at night. So understanding what the lighting levels will be viewable from the street and from the residential areas, and what your operation is for the lighting, like what's on when you're working there and what do you turn off when you leave so that stuff's not on at 2, 3 o'clock in the morning. So those are the questions that I will have more of. But everything looks very doable, but just understanding that, and also us being consistent with some of the other waterfront properties that we had that were near residential areas.
Yes, very valid questions, and we'll get those addressed.
If I'm not mistaken, you're also looking to practically double the size of the maintenance and repair area. And I'm curious as to, I recognize that you want to upgrade it, and I understand that a facility that's over 30 years is probably benefit from significant upgrades, but could you give us a little bit more detail about what you have in mind?
Sure. Beck, let me defer to you, and you can speak to the details on this.
Thank you. Sorry. My name is Beck Bennett. I'm the Vice President of Construction and Development in the Northeast for Safe Harbor Marinas. So the narrative behind the structure and why we're looking to expand the footprint is mainly to, first and foremost, is modernize the facility. Right now, we're currently working in a pole barn that's completely antiquated. Very little insulation. We have to lay off our technicians in the wintertime. We currently have 3 techs on site. They are laid off in the winter. With the addition of the structure and the additional space, we anticipate hiring at least 1 to 2 more technicians and yard hands. And 2 what was your question? And I can address it directly.
Well, I noted when you compare the square footage of the existing building with the proposed building.
Yeah.
It's not
Yeah.
quite, but it's close to double in size.
Sure.
So I mean, but there's nothing to me that suggests to me whether, how that's going to be proportioned, or I understand you're looking to modernize, but
Yes.
I have no idea.
I'll give you some context. Yeah, so what we
specifically,
do there, sure. Sorry about that. So what the shop is predominantly used for is outboard service. That is, most of our customer base there use outboards. And that's actually it's a growing trend in the marine industry, people moving away from inboard engines to outboard engines. So the predominant use of this structure is going to be for outboard service. For our customers, that can be anything from general maintenance to repowers to testing the outboards. Furthermore, throughout the marine industry, what we're noticing, and a lot of the metrics and data that we've collected, is the average vessel size is increasing. So with that, we need a larger structure to accommodate those vessels, as opposed to maybe, I think right now we got about half of a boat, and basically in there, you back it in. Yeah, and the other idea is to get the travel lift in the building as well, so we can service larger vessels as well. So that would add to our service plan, our maintenance plans. It would also be a fully heated and AC'd building, so our techs can now work year-round in the building, adding a lot of benefits, obviously, to the business.
Other questions, comments from planning board members?
I have a question.
Go ahead.
Hi,
How
I have
are
some
you?
questions too.
Sure.
Okay, so is it presently all paved, or do you have gravel or other impermeable?
It's partially
permeable
paved.
surface? Okay.
It's partially paved with gravel throughout most of the lot, basically by around the pool area up to about where the clubhouse is, and I believe right out in front of the current workspace, that is all gravel.
Okay. And I'm just thinking about stormwater infiltration.
Yes.
Certainly the renderings show that it's all paved in the area of this building, and is it now, and does it need to be?
So what we'd like to do, that rendering is correct in the sense that we would like to extend the paving, and there's several reasons for that. Mainly they're safety related. When we go to move boats around on gravel, typically it's harder on the equipment as far as the forklifts, the trailers. It tracks that in and out of the building. So ideally with this new building, we want as clean a space as possible for everyone to operate in, especially when we're working on engines and on boats. And again, it really comes down to a safety issue. I think it's a very modest amount of paving improvements, and obviously we'd be looking to capture that through stormwater management, proper stormwater management procedures. One of the systems, and Seth kind of mentioned it, that we've used at other sites, which is approved by DEM, is the Ferguson Rain Gardens, which is a small footprint stormwater management system. And we would obviously be in compliance with whatever impervious surface that was added or that we requested.
Thank you. It looks like you don't have a stormwater system right now at all on site?
That I can't speak to, but I would venture to say no.
Can you tell me what happens during a big rain event right now? Like, are you underwater, or does that gravel parking lot sort of absorb? Like, what is your stormwater situation right now?
There's a lot of there's some runoff, a lot of it percolates through that gravel lot, and again, we're not looking to pave that area closest to the water, basically from the base of that pool area up to the travel lift pit. We have really no intent, we're not looking or applying for any permits or applications to pave that area. It's really, when you come outside the building, the direct service area, which a portion of it is currently paved, your aprons that come outside the service bay doors. It's really important that those areas, in my experience, are paved or concreted. Again, due to the safety concerns, when if you're trying to push a boat into a building, let's say with a trailer, and you don't have the appropriate apron there with the appropriate grade, a lot of times that fetches up and you're trying to push and push, and then it kind of gives and goes over, and that's very dangerous.
Yeah. Okay, thank you.
Yep.
So it sure is a lot prettier than the old building.
You can thank our architect.
There's absolutely no
Yes.
question about that.
Yeah.
And I love that you're using so much glass.
Yep.
But it's interesting, we just reviewed the new high school project,
Mhm.
which has an awful lot of glass.
Yeah.
And they've installed some technology that will minimize bird strikes.
Okay,
And I think that in this location, you might want to think about
sure.
maybe trying to do some kind of remediation for all of this glass, so you don't end
Yeah.
up with a little graveyard of birds every morning when you come into work.
I completely agree. And I think a lot of that glass was to take advantage of ambient light in the area and reduce. Obviously, Safe Harbors, we have a pretty extensive ESG program, so that's why we're also discussing solar panels and EV charging stations and things like that. Also, through all of our buildings now in the network are getting audited for energy efficiencies and LED usage. So to your, I think one of the other members here asked about lighting concerns. Everything would either be timered or everything, no one's really working there into the late hours. It's a pretty set schedule where our technicians work is during the daytime, normal operating hours. So those lights would be turned off at night, and then exterior lights, I can't remember who asked the question. All of our properties try to comply or do comply with dark sky compliance. So whatever that would be anything exterior would be dark sky compliant. But to your point about the bird strikes, yes, and we would certainly work and are open to every suggestion that you would have about that. The other thing of note about glass, on the south-facing side, we're looking at thermal heat transfer doors, which offer a lot of efficiencies as well. It's an opaque glass that actually takes sunlight and can help provide a lot of ambient heat into the building. I've seen several of them up in Green Harbor, Massachusetts, in a building we have up there, and they've worked out great. And I think they're more conducive to bird strikes as well because they're opaque and not a clear glass.
I'm impressed with how thoughtful you all have been with this design,
Thank you.
especially with the environmental concerns.
Yep.
That's really great. My last question, and this is more of my lack of knowledge.
Sure.
So you are reusing the space where you've had OWTS? And is that, I've never heard of doing that before. I thought it needed to
So
be
I would defer to the engineer on that.
Yeah.
And he
Could you explain to me how that works and if there's any concerns about that?
Yeah, Seth Lemoyne from Principe Engineering. The site has a lot of constraints associated with it and the existing utilities, and this was the best suited location for the system given the soil conditions on the site. So the new system the old system will be removed. It'll be backfilled with basically a concrete screen sand, and then a new system put over the top of that. It's a different system. The old system was a typical infiltration basic system. The new system will be a pressurized, what they call bottomless sand filter. So the system's going to be close to flush with grade. Yeah, it'll have a small rise above existing elevation, but not by much.
And the rise above is a natural lawn material, or is it like a box?
No, it's going to be like a box.
On your map, there's a grassed area adjacent to the pool. Is that going to remain grassed, or is that one of the areas that will be an increase in pavement?
We're showing that as grass.
Okay. And assuming that the peripheral areas will remain vegetated as they are currently?
Correct.
Okay.
Correct,
And
yes.
you have on your rain garden, you have a list of plants, proposed list, and the sizes. You'll just have to make sure when you come back you have the actual amounts.
Okay. Make sure we list those.
And definitely, if you can do the solar panels, that's great. Huge improvement on this project.
And as far as the elevated rise of the new system, it's less than 1 foot from existing grade.
Anything
you.
else from board members? Mark, anything from DPS at this point in time?
Nothing at this time, sorry.
Okay. Jamie, anything from staff?
Probably the only thing, if you can take a moment to expand upon, is southwest of your proposed new building, you appear to be installing a stormwater feature. So between the new building and Pond Street?
Can you go
Correct.
to that map?
Yes, correct. That's,
That's where boat storage normally occurs, but you're now going to have side slopes, and so can you explain maybe where boat storage is going to go, or it's going to be reduced because you're losing that square footage?
correct. It would have to be reduced if we were going to utilize this current system that we've proposed. However, we are investigating a proprietary system that Beck had mentioned earlier through these smaller rain gardens that have been approved by DEM. So we're currently investigating that. We haven't gotten too deep into it at this point in time.
Again, just clarification, there's probably 10 to 12 boats in that area right now. So again, understanding how you're going to utilize that
Can you
area.
just show us with the cursor the area that you're describing, please?
So Brian, top left corner? So then the majority of that area right now is proposed as a detention base and retention area with 3 feet of elevation change at a minimum. So again, not flat for boat storage.
No, boats would not be able to be stored in that location. Also, the building does expand that direction towards the west.
Right.
So some of that boat storage is taken up by the new building, and then the other portion would be by the proposed BMP or bioretention system we have.
Susan?
Hi, so I have another question. So we've seen this location before where the organization was proposing a large boat storage building. Is that no longer considered, or do we need to look at this more holistically, that if you're doing this and then you determine that you need indoor boat storage a year from now, that we need to, I know it was a separate project, but is there any potential that we need to look at the whole site because there's more planned for the future?
At this time, they don't have plans.
Just restate your name,
I'm
please.
sorry,
Thanks.
Matthew Landry, counsel for the applicant. This is all that's being proposed at this time, but that's a fair question. The boat storage is on site outside. There's no intent to construct an interior boat storage space that would obviously have to come back in front of this board. This is really just the maintenance facility that's an immediate need to service existing customers. I will say there was a conversation, most of the residential properties are to the south of this, so dark sky compliance, the location of the building. There was an concerted effort to move this building further north away from those residential properties. There's one owner in particular, I don't recall which lot, maybe Beck may recall, but there was some concern about where the location of that building would be. And as far as we understand, they are more satisfied now that this is being moved further north. So that was a concern that came up. We believe it's been addressed, but at this time, there's no interior boat storage contemplated for the site. It's really just the expansion of the maintenance facility.
Sorry, before you sit down. So potentially that interior boat storage is no longer needed, or at least not for the foreseeable future.
Not for the foreseeable future. I don't know if Beck wants to comment on that, please.
So, Beck Bennett, there is no intent to develop that side of the property. We ran into a lot of headwinds with the neighbor, and trying to be good neighbors, we conceded and basically let that, put that to rest. Hence why so Alex O'Coin is here. He's the general manager for Safe Harbor Silver Spring. When we looked at when I do a lot of master site planning, so when you look at a property holistically and where the future of it's going and how you organize operations on the property, obviously very important. When we spoke with Alex about this, we felt that refocusing on the maintenance and upgrading the maintenance facility was really the best use of the property. We didn't really see where the ROI was really as strong as it needed to be for an indoor storage building there as well, so that played into it. And with the new ownership that we currently have, that's a huge factor. So this is where we found the best use of time, resources, and labor to grow the business, that also was being mindful of our neighbors. Thanks.
Anything else from anyone? Thank you very much. Good luck.
Thank you. And just leaving it, Chris is here, the architect. If there's any questions or you want additional commentary on the conceptuals, if there's any feedback as to that, we would welcome it. If you want to solicit that feedback, I would appreciate
Definitely.
it. Chris, do you want to speak briefly?
Chris Fagan. Yes, so we put together this proposal for the building. Really, I think the biggest thing that was driving it was the use of the doors. So these are very, very large doors that essentially Safe Harbor is going to need to drive a travel lift in and out of. So that was really the predominant driver for the building, was trying to get a space that was large enough, would work with the site constraints. We also tried to approach it from a aesthetic standpoint, kind of keep it more in traditional New England materials, glazing, and create a surface that we could do solar on, hence why the long pitch roof worked well. But I'd certainly entertain any questions if you had. No.
Questions from anyone?
I have one question. So the solar that you'll have on this building will power the building itself or the whole site? Like, what are your plans for, like, how much solar power can you generate, and how much of the site will you be able to get off the grid?
I think that analysis is like yet to be done.
Yeah.
So it's a matter of talking to some solar contractors and trying to find out what programs would be most suitable for this project.
Yeah. The
But-
solar's great. Thank you.
No problem.
Anything else? All right. Thanks very much.
Thank you for your time.
Thank you.
Our next agenda item is recommendation to the town council, advisory opinion to the town council regarding proposed amendments to the town zoning ordinance relative to rental dwellings as shown on Exhibit 1 attached. Jamie?
So, Madam Chair, under Agenda Item F1, you reference Exhibit 1, which is a attachment associated with a recommendation from Town Council to amend the ordinance with regards to how they register rental dwellings. And the memo was, and regulation was prepared by legal counsel, and I'll turn to Peter at this time.
So just to give a little context about where this ordinance came from, the town, a little while back, enacted an ordinance to register short-term rentals, and Narragansett had a similar ordinance, and Judge Taft Carter out of Washington County came out with a decision over this past summer, not this current summer, but about a year ago now, finding that Narragansett's ordinance was outside the scope of its authority, and she suggested in that decision that it might be more proper if it was passed as part of the zoning ordinance. So what this ordinance is taking the rental registration, putting it into the zoning ordinance to deal with that legal issue. It's also broadened the rental registration further than that. The council has been looking to get information to potentially implement a homestead exemption. A homestead exemption for owner-occupied dwellings. And so as part of getting that information to see what the impact on the town's budget would be, they'd like to get a registry of how many occupied and not owner-occupied rental dwellings there are in town.
Peter, can you also, and I know we've discussed this in the past, Judge Carter's decision relative to requirements for potential changes to the zoning ordinance beyond a registration, such as what Newport has done, and the Short-Term Rental Commission chaired by Rep. Carson has discussed this quite a lot.
So I think the current consensus between, it's a little bit up in the air since there's no Supreme Court decision deciding this, but the current consensus through the lower courts is that you can regulate short-term rentals through zoning, just not outside of zoning to create like a registration or a licensing scheme. So there are cases that say that you can, for instance, not allow it within certain zones in town. Now, whenever you regulate something through zoning, you need to allow for existing uses, but you can prevent additional uses to go into certain zones. The one caveat I'd add to that is that the city of Newport currently has a case pending where they have a zoning ordinance that prohibits short-term rentals in certain zones.
Yeah.
It was challenged. They won in the Superior Court. It's currently on appeal to the Supreme Court, so we don't know how that's going to turn out. But if if Newport wins that case, then it would be a good sign for all the other towns.
And you said that essentially existing, if that were to happen, existing properties would be exempt. Or grandfathered, rather.
Right.
How would the enforcement work on that if some of those factors were still unknown?
So, luckily, there's a lot of case law, not specific to short-term rentals, but about pre-existing non-conforming uses with zoning generally. And the case law says that if a property owner thinks that they have maintained a pre-existing non-conforming use prior to the enactment of the new zoning provision that they want to have grandfathered status for, it's on them to prove it. It's not on the town to prove it. And unless they prove it with satisfactory evidence to the town, then the town will proceed to assume as if they are not. So I think that if a homeowner keeps good records, they probably would have evidence to show that whether or not they've been maintaining a short-term rental, because they'd have to register on Airbnb or whatever website they've been using, and I'm sure there'd be a record of that.
Also, so as you know, this board has been discussing forward movement with regard to short-term rentals for quite some time as a way to better manage some of the decrease in available housing stock. How would this request fit into sort of our overall big picture discussions that we've had? Is this a initial step in part of a longer range program? How?
I think it could be an initial step. I think the hope of this ordinance is just to get data about how many rental, non-owner occupied rental dwellings there are in town. It's not going to tell you what the number of short-term versus long-term rentals, but that could be, could be an incremental step towards that direction. Although I think the primary concern with this ordinance was the homestead exemption, to get data for that.
Yeah, I was not understanding the nexus there initially.
Yeah, I think the council thinks that if they can get the registration showing these are the amount of people that have rental units that they're not occupied, they'd know that this is a part of the tax base that would not qualify for a homestead exemption.
Okay.
And so that way they would know how big of a homestead exemption they could enact and how it would impact the budget.
I see. Susan, did you have a question?
I do.
And then Robin.
Could I just ask a question on the process and what our planning board role is in this exercise?
So anytime that there's an amendment to the zoning ordinance, and because of Judge Taft Carter's decision, that's why this was put into the zoning ordinance. So anytime there's an amendment to the zoning ordinance, you need to give an advisory, doesn't need to be an extensive opinion, but just, excuse me, an advisory letter to the council, giving your thoughts on whether or not this is consistent with the comprehensive plan and whether it's consistent with the overall purposes of zoning. They're laid out by statute, but you would know what they are as well. It's about all the aesthetics and maintaining the community and all those other things.
So in addition to an approval, a thumbs up or a thumbs down on this, are we also able to make suggestions to the text and the requirements?
You can.
Okay.
It'll just be a suggestion, and the council can weigh it as they see fit.
Robin and then Liz.
Thank you. So how about a situation where the University of Rhode Island buys a building, a house, with something like the house on Commodore Perry Highway that we discussed. So does that become an institutional dormitory? And if so, can they rent it out during the summer?
So my initial thought on that hypothetical is that it would not turn it into institutional use if it's just that you or I happen to buy the house and they're using it as a dwelling for students or faculty or whoever. If it's just a house, that would just be a dwelling under the zoning code. Now, because URI is a quasi-public corporation, and is run by a board appointed by the state, they have a little bit of a unique structure when it comes to zoning regulation, which is they need to follow all the requirements and apply for the permits that they need to apply for. But if they are denied at the local level, they do have the right to appeal to court, and they can make a different argument, which is weighing the state's interests and whatever the reasons they're putting forward for that use against the local interest in enforcing the zoning ordinance. So they have an additional argument they could make, but on that hypothetical where it's just they're buying a house and they're using it as a dwelling, I really don't see any reason why they shouldn't be treated like any other person that buys a house and uses it as a dwelling.
And so maybe we need to put that into some language in the amendment, because I know URI is under a lot of pressure to increase their amount of housing, and they might start getting really creative and kind of operate through some loopholes. My other comment, sorry, was item C, the filing date. Like, that's such a horrible time of year to have to take care of paperwork. And if you do it before December 31st, it ends at December 31st? That doesn't make a lot of sense to me.
Liz?
I think I found the answer to my question. I was going to ask you, Peter, if the form itself said how long the lease was, and I see, in fact, it does. Would you just clarify that? But it looks like the form does state whether it's a long-term or a short-term lease. Is that in fact true?
I think that's the intent, is to get that data so they can break it out. It wouldn't even be for regulatory purposes at this point.
Just for information?
Just for informational purposes.
Okay. Thank you.
Joe?
So I think mine's going to be more of a comment and something I think should be taken into consideration, more so than a question. But, we talk about affordable housing at the municipal level. We talk about affordable housing at the state level. We talk about the need for apartments and affordable apartments. We try to make some corrections by passing regulations which allow increased densities, which has an impact, so that we can have more affordable housing. We just take taxpayers' money and we put it in a fund for affordable housing, which comes at an impact. And when we create an additional housing, we pat ourselves in the back like we did this great thing, not necessarily recognizing that we're the ones that are causing the problem. These regulations, as a landlord, I have to put fire alarm systems in my buildings that you don't have to if you're residential. I have to pay for an inspector to come every 6 months, which you don't have to do if you're residential. I have to register in the state lead laws and register all my properties. And then, after everything passes, I need to still get them inspected every 2 years. Even if everything passes, I still got to get them inspected and go through that expense. I have to pay a higher mortgage rate than what you do if you are residential. In some towns, I have to pay higher taxes. In some towns, I have to pay for the garbage disposal when the residentials don't have to. I have to pay by state regulation. I have to offer recycle that residential no. So, I understand the good to this, but we also have to understand that all our talk at a municipal level and a state level about affordable housing and all the good things we have to do, these types of things are the problem. We are causing the problem with all these additional regulations, and now we're saying, hey, what we can do is we can shift some of the tax burden from the people who live here and own property to the people who live here but don't own property. Because that's all that the Homestead Action does. It's still going to result in higher taxes or higher expenses to the people who don't own homes, that live right here. I guess, maybe the thought is, hey, they maybe won't vote, but all we're doing is passing additional costs on to the most needed portion of society. The most needed people in our community is who we are going to pass the cost on to. So I just think that needs to be recognized.
Joe, I just have a question for you. So you were talking about residential uses, short-term rental versus year-round where you have a higher standard?
No, all these things are for long-term. All these, everything that I said is an additional cost, everything that I said is an additional cost for every tenant to any long-term property. Now, if you want to go short-term, now your insurance goes from, on a single-family house, goes from about $2,000 to $4,000. But all the additional expenses that I just talked about is just on long-term, is being placed on long-term tenants. Long-term landlords, but long-term tenants through the landlord. So it's just, we already have regulation after regulation at the municipal and the state level, just makes rentals, we're causing the problem.
Robin?
Well, so I saw like a $100 fee or a $300 fee. I don't see a lot of other expenses that, and you're saying as a landlord, you're going to push that burden on your tenant.
The cost to build, operate, and manage an apartment building in the long term is paid by the tenant. Otherwise, if it doesn't cover it, then there's no more property being built. I mean, it's just like any other business.
Testing for lead is a good thing, right?
What's that?
Testing for lead is a good thing.
Yeah. Interesting about lead is a long-term rental. You have to have it inspected. If it's a short-term rental, no matter how old it is and know how bad it is, you don't have to do anything. So.
Very interesting.
So,
Susan?
too many people. So Joe, would you advocate for this, that there's a $100 filing fee for people who own less than year-round rentals, and that the registration is valid, it's just maybe that cost should not be shared with landlords who have year-round rentals? That shouldn't be assessed, which is reasonable, and I'm just asking if that would be a solution, is that, if we think this is a great idea, maybe year-round rentals aren't assessed the $100 fee. And would that be a solution?
I'm not sure if I understand. If you're asking if the registration only applies to short-term, or your registration applies for everything, but only short-term rentals receive the fee. I think it's probably better for your long-term residents in this town, this part of our community that rent. I get that. I mean, it still adds additional costs for other phases of the business. But if you're looking to protect our community, if you're looking to protect the most needed in our community, you would not impose any additional costs that's required for somebody to provide them housing. So any type of homestead, it's all it is passing on to the cost to those people who don't necessarily have a voice. That's all it is.
So it's not just the $100 fee, it's also this homestead exemption that should be shared with year-round tenants as well as homeowners.
Jamie, am I correct in assuming that the conversation has just been initiated with regard to a homestead exemption, and it has not been thoroughly vetted, and is that correct?
So the council has discussed with the town manager's office and the finance department the implications of a homestead act, and again, it's an ongoing discussion. It's something the town council is exploring, and this is part of that exploration, as Attorney Schwartz has mentioned to you this evening. I think the discussion's been good tonight. From our perspective, you have a referral from the town council regarding a registry, and your guidance back to them, and I'll have council weigh on this, is how does this change affect land use and zoning in town? And are there any inconsistencies with the comprehensive community plan that's been adopted? And I think that's what council is looking for you for guidance on that effect. Peter?
You know, I think that's fair, and then I think it's also true that, you know, at this point, I think this ordinance would just gather data which could be used to make an informed decision by the council, whichever decision the council makes, you know, because at the same time, not to take any side on the issue, because I don't think that's appropriately my role, but there are going to be people that are going to advocate on both sides of the issue. It is an issue that's been teed up for the council, and at this point, you know, they've said, well, we want to know what's out there, we want some more information so that we can really understand this issue more. So I don't know, I guess all I'm saying is just because this registration passes, it doesn't necessarily mean that the homestead exemption would follow on that, or that it wouldn't follow on that. It would just give them the information to understand what's out there a little bit better.
And had there been any discussion relative to registration for short-term rentals only? Do you know?
Yeah, so there initially was a registration for short-term rentals. That was the initial iteration of this ordinance when it was outside of zoning. And that is what's being replaced, in effect, by this because of the Taft-Carter decision.
So I have two comments on the actual ordinance itself. One of them was something that Robin had mentioned, which is that it needs to be filed by December 31st for the following year. And then it says, if you register it during the year, it shall be for the same year. And I don't understand that consistency where if I file in October, am I filing for the year I'm in? Am I filing for the following year? Like, I think that needs to be clarified of what's the register during the year means if December 31st is a deadline. It's confusing. I think it'll be confusing moving forward. And the second thing is that if you have long-term families living in long-term rentals, I think that requiring them to post the lease and a registration on the inside of their front door, I don't know, man, that sounds pretty harsh to make a family post their lease on the inside of their front door in their family home. And I certainly can understand having it for short-term rentals posted somewhere that someone can see it, but long-term families living in rental homes, I don't think need to have that sort of thing posted to the inside of their front door.
Yeah, I agree as well.
Oh, sorry, and my last thing is that there seems to be a penalty if I don't pay my fee annually, but there doesn't seem to be a penalty for just disregarding the request to register my short-term my rental. Like, I don't think there's a penalty if I just pretend I never saw this ordinance. So I think if you're going to ask for compliance, you might need to put a penalty in for folks that just disregard it altogether.
So a couple of points. First, is the posting of the notice. That's a fair point, so I think you can just make that recommendation to the council. As far as the language and the filing date, I think the date of the filing can change. That's to whatever the council thinks is more convenient. I think the intent of the language was just to say, if you file prior to the year, you would be registered for the entire year coming up. If you miss the filing deadline, it's not that you're out of luck, it's just that you can file in the middle of the year, and that would cover you for the remainder of the year, even if you file late. As far as the penalty, so you're right, there is an express provision about a penalty for not paying the fee on time, but there is a general provision that allows for a fine of up to $500 for any violation of a zoning ordinance. So I think that general penalty provision would apply to this, since it's part of the zoning ordinance.
Is there anything in the Taft-Carter decision that would prevent eliminating the long-term rental portion out of this registration requirement?
It wouldn't, but I think the reason that when it came back again, I think the way it happened was there was the short-term rental registration, then the Taft-Carter decision, then there was a second look at it, then there was a decision that at the same time they wanted to get more data on this homestead exemption issue, which is why this iteration expanded the scope of the registration.
So, go ahead, Joe.
All right, so I just want to go on the record that my comment is that any regulation that results in increased costs to the South Kingstown residents that rent, either directly or indirectly, through additional costs or administrative burden to the housing provider, is contrary to the affordable housing elements in our comprehensive plan.
So Joe, what would you say if the fee were much more affordable? I don't think you have a problem with collecting data, right? It's
still adding cost. I mean, I'm not even saying I'm 100% opposed to this, right? All these things, all these regulations, every single one passed by the municipality, every single one passed by the state has some good. It's good that we recycle, but it costs money to the tenant. It's good that we have fire alarms, costs money to the tenant. It's good that we inspect the rental units for lead, but we don't, even though we don't inspect residential, but it has a cost to the tenant. It's good that I get those things inspected every 2 years, but there's a cost to the tenant. It's good that I have the fire inspection come every 6 months, but it's cost to the tenant. It's good that I have to have fire extinguishers and they need to be inspected, but there's a cost to the tenant. It's good that I have trash removal, but there's a cost to the tenant. So yeah, it could be $10. That's fine, but recognize it is still a cost to the tenant. It is still contrary to making housing affordable.
So we're saying maybe that it needs to be subsidized.
I'm just going on record and let you know that don't look just at the good. Let's look at the whole package. And we are making it more expensive to the most needed people in our community.
I do, I hear you there. But I think that those inspections are important. So maybe the state needs to subsidize these things.
So it would be prudent for the board to provide a fairly timely response to the council on this. Clearly, they're looking at this particular portion of what we have discussed as an overall strategy relative to short-term rentals for a particular purpose. However, I think we need to talk about some of the comments that were brought up tonight and how best to respond to their question. So we've talked about the posting of the lease and the, excuse me? Yep, the filing date. The filing date, yes. Peter explained the penalty if the ordinance was just disregarded. But I think we should give Jamie some bullet points to add to a response, which...
I have 3 items, Madam Chair, based on the discussion, and again, this is baseline discussion
Certainly.
information. Item number 1, recommend that the council clearly include language that clarifies the time period associated with the registry dates and the annual application deadline. 2, evaluate the need to post the registry notice and/or lease information within a property. Or I should say property/unit, because you could have a multiple.
And you want to specify that that is specific to long-term rentals? Correct? Because I think we all agree that on the short-term rentals, that's probably a reasonable and necessary thing.
And 3, evaluate the cost of the registry fee against the increased cost to renters as it relates to the community's goal of providing affordable housing within the town.
On that particular point, I think we need to be a little bit crisper, because the fee, as I read it, the last part of the section on the fee says that rental units owned by South Kingston Housing Authority and rental units that are deed restricted as affordable housing shall be exempt from the registration fee. So I think that whoever's drafting this is thinking that they've already accommodated the lower income housing component of this.
Again, I discussed that language with Attorney Orsillo regarding that and Amy Goins, and one of the things is, South Kingston Housing Authority receives some funding from the town, so if you're charging them a registration fee who's supplying 100% affordable, you're basically charging yourself. So there were some aspects of that added to the language from the original draft.
And
So could you read your bullet point number 3 one more time?
Yeah. Evaluate the cost of the registry fee against the increased cost to renters as it relates to the community's goal of providing affordable housing within the town. Yes.
I think it's stronger than that, or maybe it's an additional one. I think we should specifically state that South Kingstown currently has a severe shortage of residential rental units, and in particular in affordable. Anything that increases the cost will exacerbate this problem and goes against the housing elements in the comprehensive plan, affordable housing elements.
exasperate and exacerbate. Is there consensus in the idea of making the suggestion that, as Joe had said, the additional fees, applying those to long-term rental may exacerbate the kind of higher standard commercial level costs associated with those two types of rentals, or with the long-term rentals? Yes?
Yes, I think so.
Yes, but I think I would be in favor of submitting exactly what Joe wrote. I think Joe was very clear and concise with his connection to this issue with the comprehensive plan.
But it makes it sound like you don't want any fee, whereas I think the short-term rentals fee you're okay with. Yes. Separating the two types of...
All right, so I'm going to separate, be very honest,
Okay.
separate two pieces of me. One is looking out after the town's most needed community, and that is residents that live here. So any fee that is attached to a long-term property affects our community. It directly affects those people around us that need it the most. And then there's the business side that, any increase, of course, is going to have effect on the business and, doing business in South Kingstown. But that is a smaller element to me than, I shouldn't say to me. To me, it's just as big. But to the community, that's not as big of an issue, I don't think. I think the bigger issue is looking out after the most needed people in our community, and that's going to be affecting the long-term renters. So I'm against both, but I'm against one more than the other.
But I'm not sure about the phrase, the most
Good to know,
needed
Joe.
community, the most needed community.
Madam Chair, I'm trying to phrase a sentence, if you can give me a moment.
And just another point, I'm going to tell you, for the single-family houses that I have in South Kingstown, the ones that are renting, these are the people that would like to buy. These are the people that can't afford to buy. And what we're going to end up doing is just making it even harder for them. If you have a family living in South Kingstown in a rental unit, it's because they could not buy a house, and now we're gonna make it more difficult on them. Now we're gonna increase their monthly amount, make it harder for them to save. That's what we're doing by doing any type of homestead.
So do you think we should change the language instead of what you had said, most needed to financial burden or financially burdened? To make it more clear.
Hopefully you have what I have in light, but I'm recording, but I do think that we have to make it a point that, especially on our long-term residents, these are the most needed people in our community, and we're making it harder for them to eventually buy a house. We're making it harder for them to survive in our community. We're making it harder for our workforce, the people that work in our community, they can't live here and they can't rent here. And we're not the solution, we're the problem. That's what we need to recognize.
So then isn't it an issue that we don't know how to collect this data without some type of registration process?
Well, I guess, what are you collecting the data for? And if it's a data, just, again, my point is, in all this stuff, there's good. But don't go into it just looking at the good. Realize the harm you're causing too. So maybe collecting the data, depending on what you're going to use for it, is not necessarily a bad thing, especially if you can keep that impact away from those rents.
I thought that was the intention of the registration, was to know how many rental properties we had.
But then I asked, what are you doing with it? But
Well, that's the intent of the legislation, but the intent of the fee is to defray the cost by imposing the cost entirely on the landlords, who will in fact turn it over to the tenants.
I agree. But the question remains, how do we get and not
I don't think, Joe,
put a burden on needy people?
maybe I'm misunderstanding Joe's point, but I think he's not objecting to the registration. He's objecting to the deferral of the defraying of the cost by imposing it on those who are registering the properties.
well,
It's the fee.
I kind of go back to my original comment, which was any regulation that results in an increased cost to the residents that rent in our community, either directly or indirectly through additional costs or administrative burden to the housing provider, is in direct violation of our affordable housing elements in the comprehensive plan.
Did you say long-term the first time around?
It was meant to be in there.
Okay.
Again, paraphrase, because Joe was writing while I was writing. So again, I'm paraphrasing what Mr. Murphy said. I think one of the difficulties is the $100 fee equates to $8.33 or 34 cents a month. So I think it's hard for me as a professional to determine what dollar amount makes it unaffordable, any less affordable or any more affordable, or just changes the profit margin of a landlord or a landowner. So I'm trying to find some middle ground. And just my sentence reads, again, item number 3, to evaluate the cost of the registry fee against the increased cost to renters as it relates to the goal of providing affordable housing within the town. New sentence after that. Any additional costs added to year-round rental properties by the town could be deemed inconsistent with the goals and objectives of the town's comprehensive community plan. I'm not sure you can put a definitive dollar amount. To Joe's point earlier, or I think Robin or even Susan, what if it was $25? What if it was $50? I understand Joe's point that any amount, even $1 potentially, could be deemed to affect, but I don't think you have the data to get there.
So I'd make 2 comments. One, any amount is contrary. Any amount is making it harder for them. The other thing I think is very misleading, and when you look at what the cost is and then you just divide that by the tenant. I will tell you that whatever inspection I have for the state, there's an admin cost to that. There's somebody tracking that. For every lead inspection, I send an admin person there, right? So the cost is more than double of what the actual, for lead inspection, it's about $250. I have to keep track of that. I have to send somebody there. I have to respond to whatever issues that they have. That could easily be 3-4 times that per apartment. Easy, easy. So there's administrative burdens cost the tenant. Somebody has to make sure those certifications are sent into the state. Somebody has to respond to the state. Somebody has to go on these inspections.
And I'll defer to council after I make the statement. What's before you tonight is the rental registry, not other, I understand, I absolutely respect Mr. Murphy's point that there are other costs associated with owners of rental property, but those are already here, they're in existence. What council is trying to do is, via a change to the zoning ordinance, do a rental registry. The impact of that rental registry, just on its face value, is $8.33. Face value, Joe. The check you have to write out to the town. I don't know what the administrative costs are to fill out that application. I don't know if it takes an hour or 4 hours. That's why, again, that's a straight mathematical calculation. I don't know the administrative side. The same thing as your reference to the lead registry and inspections. There's a fee, and then there's a cost by the landlord, right? So there is a cost beyond the $100, in essence, check you write, which Joe has pointed out. He's clearly stated that he's of the opinion that any cost, even if the fee was and I don't want to bore you, even if it was $1, there's still that background administrative cost, Joe, correct? And we don't know what that is. But you're concerned about any additional fees potentially impacts or conflicts with the town's comprehensive community plan's objective of supplying affordable housing to the community. What I'm saying is I don't know if you can clearly quantify it.
Yeah, I agree. I'm not trying to quantify it.
Yeah, and
All
that's why I'm
is that
saying
any regulation that results in increased costs is contrary to the housing elements in our the affordable housing elements in our comprehensive plan. That's the point that I want to make.
So, Madam Chair, just to respond to that briefly, and not to weigh in on the ultimate goal, but, using the lead abatement as an example, there's obviously an upfront cost with getting the inspections. But to say that those costs impose a cost on all the tenants, I'm not sure that it accounts for the benefits that also come from regulation. So on the one hand, they may have an increased cost in rent, but on the other hand, if their child doesn't need to get treated for lead poisoning, that's a significant benefit that may be worth the cost. In this case, I'm not sure it's not in the same ballpark as that, but, for instance, if the data gets back on this and the council says, you know what, now that we see the data, we're deciding we don't want to have a homestead exemption. And I'm not saying that's what they're going to say. I'm just putting that as an example. On the one hand, there's a cost in collecting the data and just the administrative burden. Put the fee to the side for a minute. But on the other hand, is it a potential benefit that you have an informed council that passes, an appropriate regulation that saves costs in the long run? Or, alternatively, they find out, here's the amount of short-term rentals in the town because of the data they get back. And with that, they've passed an informed short-term rental zoning ordinance, which, although not directly, maybe indirectly, could affect the costs for long-term rental tenants. So, there are costs and benefits on all sides. It's tough to weigh them all out. I think maybe if you make concrete recommendations, as in, we think you should get rid of the registration fee. And that could be a recommendation the council could take up and say, you know what, they recommended it, maybe we'll do it. Maybe we don't need to collect the $100 from every applicant. And maybe they won't. But to say that, you know, any regulation will have a cost without considering the potential benefits on the other side might not give a full picture to it.
It's also my understanding that specifically for short-term rentals, Newport instituted a fee, and they have then utilized those fees for enforcement issues, which has helped them quite a bit. We're not there yet, but
Yeah.
But short terms are registered at the state already, so there is a registration database for all short terms.
There are, you know, there could be a benefit
There's-
of getting, you know, getting a second run at the data on that to cross-check it, but there is a state database as well.
Just to
Airbnb.
clarify, the state database is only short terms on a hosting platform.
Right.
right, yes, I remember hearing that there were some limitations with regard to that, and that's something that the Short-Term Rental Commission has been discussing for quite some time.
On the issue of the data, as somebody who is involved in a lot of the data gathering that comes from the state and Rhode Island Housing, we don't currently gather this data right now on rentals. If you go to the Rhode Island Housing Fact Book and look at the South Kingstown page, you find zeros in all of the rental questions because we do not have the data. That data will not only inform the town council on a homestead exemption, but it also informs this board in terms of zoning changes that you may want to make to encourage housing development and forms of affordable housing throughout town in terms of types and locations. And it will also inform the board and the council when it comes to the next iteration of the comprehensive plan and how you might want to make changes there as well. So having the data is important to making responsible decisions going forward.
I agree with you on the data. I mean, we have, with all the land use legislative changes that have occurred without gathering data, unlike what they've done on the Cape, where they have actually gathered data and done an analysis of infrastructure needs prior to passing land use legislation. Kind of the smart way to go.
So can I ask a question, maybe Brian can answer? So Joe pointed out that he needs to have his rental units inspected annually for lead paint, but I don't have to have my house inspected annually for lead paint. So there must be some registration out there where they know to have him do an annual lead inspection.
Once you have that initial inspection, then you're in there.
Well, the state's requiring that you register any property that's, was built before any rental property that was built before 1980.
So they have that database.
Yes. Well, yes, they're building it. It's a requirement, and people are supposed to conform, and I'm conforming, and it's hurtful. It's really hurtful, which is a whole other discussion, but.
Yeah. You know, and I think, obviously, Joe, whenever the new law comes out, he's staying informed and he's going to keep up on it. That doesn't necessarily mean that every renter is either complying or that the state knows of every rental unit that needs to comply and isn't, so.
Right, and I didn't understand the 1980 rule. Like, it makes sense to me, but I didn't.
That's when lead paint came.
Yeah.
You know, they pretty much ended lead paint.
So, Madam Chair, I've added one more sentence.
Another sentence or another number? Because we were up to 3, but then there
Another
was kind of the 4.
So just another sentence, just so we can see if you can be comfortable with the language. Item number 3, evaluate the cost of the registry fee against the increased cost to renters as it relates to the goal of providing affordable housing within the town, understanding that any additional cost to year-round rental properties by the town could be deemed inconsistent with the goals and objectives of the town's comprehensive community plan. Consequently, it is the board's opinion that the fee should be substantially reduced and/or eliminated.
I think we should just do the evaluate, because that way it puts it back in their court. And
Be evaluated?
they hear our, that's my opinion, I don't want everybody.
So consequently, is the board's opinion that the fee should be reevaluated?
Or evaluated as it pertains to whatever else you said about.
Okay, so eliminate that last sentence then.
I just think that we have to acknowledge that any fee should be evaluated and that it is against the affordable housing elements in the comprehensive plan. Anything that increases costs is against the affordable housing element. I agree with Peter. Everything has benefits. I agree. There's definitely benefits there. But let's make sure we're looking at both sides. That's all I'm asking.
And I hope that making it one sentence that evaluate the registration fee against the increased cost with the understanding that any additional costs to year-round rental properties could be deemed inconsistent with the goals and objectives. So it's saying evaluate it, it potentially
With the
has
understanding
impact,
that, yep.
and it determined on that impact could be found to be inconsistent with the comprehensive community plan.
Yes.
So that's one sentence connected now. Okay. Thank you for everyone's patience.
It sounds good to me. Is everybody okay with? So you'll have 3 items.
Did we also include the one about not having to post the lease on a year-round?
That was number 2.
That was number 2? Okay.
Number 2, yes.
I don't know, Maria, if you want to open it up, but I do think there might be some people in the public that want to.
So although this is not a public hearing per se, and it is the town council who has the ultimate decision, if anyone would like to briefly speak to this particular item tonight, come right up to the mic.
Hi, Roberta Mulholland. It's disappointing that the town council sent you this in this form. The town council had a hearing on this in, I think, December 23. The room was full of long-term rental owners objecting to this and saying exactly what Mr. Murphy said. Every dime that you add to a registration, a fee, affects the rent. I doubt most of the renters, the rental owners, have a lot or are in the business of it. Many of them rent a duplex or a house or a small house. And I was shocked when I read this, that it was the exact that was presented in December 23. After all those comments, and everything you talked about was talked about by the room full of people. So that's disappointing. And the connection to the homestead exemption, that just came up last Monday. I've paid attention to this because what the town needs is a short-term rental registration, because we need short-term, we don't need the registration, I'm sorry. We need regulation of short-term rentals because they are destroying neighborhoods. They're in residential areas, they're having weddings and bachelor parties, and they're destroying our residential neighborhoods. And this town council won't do anything about it. So to hear last Monday that they tied this in with collecting data and they need it right away so they can go ahead with a homestead tax exemption, I don't believe a word of it. I don't believe a word of it. We need short-term rental regulation. No, and what they passed for a policy, they took the long-term out of it. Everything that you've talked about was brought up by the people that live in this town. They heard it, and they just sent you exactly what they had in December 23. They didn't even read this, I'll bet you, because they sure didn't discuss it in public. It came on the week before Monday, a week ago. So maybe they were talking to their solicitor about it, but it's really disappointing to see them send you things with a hurry up, hurry up, hurry up, as though you don't do anything that they haven't thought about. And I'm glad I'm not you, because I would not be happy. And then you're talking about the grandfathered short-term rentals. Yeah, how much longer is that town council going to go on and on and on with no short-term rental regulation so that somebody can come in and, I've done this for 5 years. I'll take you to court. I've done it for 5 years. You've done nothing in your zoning regulation. We talked about this a year ago, September. I brought this up. Go to your zoning amendment. Nope. Look at 10 months later, you finally get something. This is destroying our town. We know it affects our residential neighborhoods. We know it affects people buying houses, putting the prices out of sight for regular people, and investors. It's changing our community. Our very community is being changed. So I love hearing all of your comments. I love that you've wanted to do something. I hope that we get a regulation. And the collection of the data, again, just came up. What Mr. Murphy talks about with that lead inspection, because I have many clients, they couldn't even get a lead inspector. The deadline was there, and you couldn't get an inspector. So once you do, that's registered with the state. There's a database for long-term rentals that is being developed. It was absolutely public. I'm not sure that it's public anymore, but I'm glad you hit all the points, but I would not be happy. You just got dumped on.
Brant White, 53 Perry Avenue. So I live on the eastern portion of Perry Avenue that has 5 houses. So a little context to here. One is a short-term rental, and one is a summer house, and you have 3 full-time residents on that street. There's only 5 houses. So, like, you know, when you think about that, that's just a little context. I'm not talking about Highland Avenue that has a duplex with college kids in it. You know, this is right in the middle of Wakefield. So just a little context for that.
Thank you. Anyone else like to speak? So Jamie, go ahead, Robin.
Can we add any verbiage to refer to regulation?
So the planning board's role is just limited. You know, I know there's been some discussion about other regulations, but your role is just to advise on the regulation that's been sent before you on consistency with the comp plan and consistency with the purposes of zoning.
So as much as we would like to reply, we've been talking about this for how many years now? And would like to look at it in a holistic manner. That's not what we've been asked. It would be nice if that message could be somehow conveyed for future consideration by the council. I don't know.
Yeah, maybe.
Can we add a paragraph at the end saying, thanks for asking, plus we would really like to, address this issue because we feel that it has such an impact to housing availability in South Kingstown. I don't know, is that
you could
acceptable?
I think maybe a better way to approach the issue is that there's 3 sources that a zoning ordinance amendment can come from.
Mm-hmm.
It can be submitted by a member of the public, any member of the public. It can be submitted on behalf of the council, or the planning board could workshop a proposal and send it to the council. So if you wanted to put on a work session, discuss an approach to, but then, the question would be, you don't know what the reception of the council would be. So you could always take that up at a work session, but, having the communication with individual council members, town staff, to figure out what the best way to approach it is, would be one.
That's a reasonable idea, is send them what we think should be the big picture starting point. We've discussed this, as you know, so many times for so long.
Yeah. And actually, the one thing that I would add is, there is that case that's currently pending in the Supreme Court challenging the Narragansett ordinance. South Kingstown, the council, did authorize our office to file an amicus brief on behalf of, in support of the town of Narragansett.
Ah, okay.
So, you know, that is an action that they did take.
Yep.
But the question is, if you act too quickly and these, you know, businesses essentially are stopped from operating from a zoning ordinance, which ultimately, if the court comes down the wrong way, could end up being invalid, you know, what is the exposure for that? You know, if could an operator or a potential operator come in and say, well, I've missed 2 seasons of operating a short-term rental because a zoning ordinance was in place that was later declared invalid by a subsequent court decision. Now I want to try to recoup my lost revenue from the town. It's a possibility.
Yep.
Doesn't mean that you can't work on something in the interim
Yep.
until that case comes down, but it's just something to keep in mind until it does come down.
Yeah, kind of challenging to work on policy issues and wait around for court decisions, isn't it?
Yeah, and you know, the issue is that this is always, it was been complicated by the General Assembly by introducing the statute that, you know, has been interpreted different ways over the years, which has led to litigation that's complicated it more. So,
Before the commission has even completed its, you know,
right,
mandate.
yeah.
Is everyone in agreement that we need to add this to a future work session? And then send something to the council at that point? We need someone to make a motion to,
So, Madam Chair, you want me to reread the motion?
the whole thing, or?
Well,
could
it'll
you
take me 2
abbreviate?
minutes, less than 2 minutes.
Okay.
When does it have to be to the council? Can you send it to us and give us an opportunity to review it and then vote on it at the next meeting?
So by statute, from the time that it's submitted by the council to the planning department, and this isn't the council putting the pressure on, this is the statute. It sets out a 45-day timeline to get a recommendation back to the council.
Well, I think there's only 3 bulleted items, so
Right.
that essentially
So again,
sends the
I'll just
message.
read them quickly. It'd be a motion to recommend that the town council explore the following 3 items prior to final action on the proposed amendments to the town zoning regulations as it relates to rental registration. 1, clearly include language that clarifies the time period associated with the registry dates and annual application deadline. 2, evaluate the need to post the registry notice and/or lease information within property/unit specific to long-term rental. 3, evaluate the cost of the registry fee against the increased cost to renters as it relates to the goal of providing affordable housing within the town, understanding that any additional costs added to year-round rental properties by the town could be deemed inconsistent with the goals and objectives of the town's comprehensive community plan.
I think it's good. Would someone like to make that motion?
I'll make that motion.
I'll make that motion. that
I'll
we approved it,
second.
yeah.
We have a motion from Joe, we have a second from Caper. Is there further discussion? Hearing none, all those in favor say aye. Aye. Nays? Motion carries. Usually we take a 5-minute break, a couple hours into our meeting, so it's an hour and 40 minutes. Everyone okay with that? I can take a break. Okay. Are we all set to continue, folks? We all set, Jamie? Yes. All right, let's continue on. Our next agenda item, F2, advisory opinion to the town council regarding proposed amendments to the zoning ordinance relative to manufactured homes review as further described in a memorandum from the Assistant Town Solicitor to the Town Council dated September 13, 2024, and entitled Manufactured Homes, Existing Local Regulations and New State Law.
So again, Madam Chair, just a quick overview. You have a referral again from Town Council regarding a potential change to the zoning ordinance as it relates to the definition associated with a manufactured home and its place on the use table. Currently, manufactured homes are not a permitted or recognized construction methodology. Council is proposing that it be added as a recognized construction methodology and therefore be permitted within the same places that single-family homes are allowed, traditional stick-built homes. And again, Peter's office prepared the memo and the proposed regulatory changes.
So, Madam Chair, really these changes can be broken into two parts. One is just a definitional change of what constitutes a manufactured home. That definition was amended to just mirror exactly what's in state law. The state law definition will govern anyway if the local ordinance is inconsistent, so that is just, it's record keeping more than anything else. The state law also provides that towns and cities they're not required to, but they may allow manufacturers' homes that comply with the building code as a type of single-family home on any lot zoned for single-family use. So in addition to the definitional change in the draft that's before you, you'll see a change to section 300D, manufactured homes, and a change to Appendix A, the use code descriptions, and those changes would implement the provision that would treat a manufactured home as a single-family home. Those are optional at the town. You could either choose to do so or not choose to do so.
Could I ask a few clarifying questions then? So as the zoning ordinance reads, manufactured/mobile homes weren't allowed in any of our zoning districts, yet we probably have close to 1,000 manufactured and mobile homes in South Kingstown. So is this being amended to try to come into line with the fact that we've got so many that aren't supposed to be there? And where is the word park important and not important?
I'll defer to council on the legal matter.
So I don't know if it necessarily would, if this is being passed to address any existing mobile homes. The difference between a mobile home park and a mobile home on a single lot, I shouldn't say mobile home, I'm sorry, manufactured home. But a mobile home park, that's regulated separately. Generally, that's on one large parcel of land where the owners on that land own the mobile homes, and they lease a space where they can, right, yes.
And
So-
isn't that more of a commercial venture rather than having a specific manufactured home on a lot?
Right, so it's licensed differently, there's other regulations through the state. So this essentially would just say, if you buy a single-family house lot in a development, if the town were to enact these changes, you could either build an ordinary stick-built home, or you could construct a manufactured home, if you make those changes.
So are we saying that in the, historically speaking, all our manufactured homes exist because they're in a park? We would have said no to them
So they
prior?
either, go ahead. But they'd either exist in a park or they'd exist potentially as a pre-existing non-conforming use, so as a use that predated zoning.
There's a couple different classifications of home traditionally, and I think, Robin, some of the things you referred to would have been considered mobile homes, where they're built on a chassis with wheels, and they're put on properties that aren't owned by the homeowner. They're owned in one larger holding, and, you know, and that unit can be moved off the property by hitching it to a trailer, still has an axle on it. Doesn't necessarily meet I believe in 1975, HUD changed their standards for what is considered a manufactured and/or mobile home. So I'll just go through traditional classifications. Traditionally, if you're talking to people, everybody understands what a older mobile home is or a mobile home park is. I think everybody understands what a stick-built house is on a foundation. Where I think two terminologies get mixed up is manufactured home and modular home. Those typically were interchangeable through the 70s and 80s and into 1990. But the primary difference, and the difference in this change of wording under Rhode Island state law and the recognition of that, is a prefabricated home or modular home is traditionally built in a factory. It is put on a trailer that is designed to carry the product to a job site. It is then lifted off that trailer by a crane onto a foundation or a slab. The structural aspects of a prefab or modular home is not integral with steel fabrication associated with a chassis and an axle. Under this definition, a manufactured home, in essence, is a unit produced in a factory, but instead of being lifted off a chassis and placed on a foundation, the steel chassis is integral to the structural integrity of the unit. It is delivered to the site on a steel chassis with the axle intact. It is either put on a temporary or permanent foundation. It is not lifted off by a crane. It is parked, jacked up, foundation placed, and then lowered back down on a foundation. It can be re-put in the air, axle tires re-established, and then driven off the property in tow. So again, traditionally, everybody had the nomenclature mobile home, prefab, modular home, stick-built. And there's just a slight change in the terminology between manufactured. So I would say mobile home, manufactured home, still on a chassis. Then you have prefab, modular, gets built in a factory, lifted by a crane, put on a foundation or a slab, and then you have traditional stick-built. Rhode Island law was modified to recognize HUD's classification of a manufactured home, which is built in a factory, on a chassis, with an axle, driven to the site, tires get removed, you move in. Chassis stays, axle stays.
So I don't see the word prefab, was it you used? I don't see that in this at all.
Good. Prefab is considered no different than a single-family stick-built house under our zoning regulations.
Okay, so we're just distinguishing between mobile homes which keep their wheels on and the manufactured homes such as in Warden's Pond or South County, South Shore Village.
South Shore Village is a prefabricated home and is not a manufactured home. Those do not have a steel chassis with an axle. Those are lifted off by a crane and placed on a foundation or slab. That's the primary difference. A manufactured home is built on a steel chassis that doesn't need another trailer to be driven to the job site. It is driven on its existing steel foundation. If that makes
Okay,
sense.
I'm struggling with that. And I think that in the original wording of either of those developments, they were manufactured/mobile homes.
Because that was the general terminology used at that time.
Okay, so now you're calling them something else, but
It's- someone
I guess my
decided to call
question
them
was,
something else.
we have so many of them already. How were these all allowed if now we're trying to change our zoning so that they can be allowed? Right, we have close to 1,000 of them, right?
So are you thinking of like places like Roy Carpenter's, Mary Carpenter's, those type of places? Yep. Okay.
South County Country Club.
Pond, right?
Yes. So just clarity on the golf course development. Those, in essence, are prefabricated in a factory, brought to a job site, lifted off someone else's trailer, and placed on a foundation. And that's why I said that the mixed terminology, to your point, regulatory, in history, from a regulatory standpoint, that was called a manufactured home. Whether it was manufactured, prefabricated, or modular. It was built in a factory, driven to a job site on a trailer that was independent from the house. The manufactured home under the state law in this new definition is that the trailer is part of the home. It is the foundation of the home, structurally integrated into the construction of the house.
It's like we're talking about medical marijuana and cannabis again.
Jamie, another way to word it that I think might be clearer is at least my understanding, in a mobile home, it's all put together. It's like a shoebox, right? And that's the house, and it's brought to the site. Whether it has wheels or not, or an axle or not, doesn't really matter. It is the house. When you have a modular home or a prefab, the walls might be already panels, right, rather than stick-built, or separate rooms might be put together as little boxes, and they're put together as a house, as big box, but it's not the entire shoebox house.
So it's more customized, you're saying?
Yes.
Essentially.
Maybe more customized, but it's showing up on a chassis.
Not the prefab.
Are we addressing the house that comes in parts, or are we addressing the house that comes on a chassis in this amendment?
The proposed amendment would allow a home that comes on a chassis that does not get removed to be considered in the same manner as a single-family stick-built home.
Can I just throw a kink in the works by asking another question? What about a shipping container house? What is that considered? Because nowhere do we say this does not include shipping containers. What if you stack 5 shipping containers on top, or whatever the height would allow?
And that is a question for the building official. Any structure would still have to meet modern building code.
But is that considered a stick-built, or is that considered a prefab? Modular?
I don't think I have an answer for that tonight.
But it's not exempt from theoretically, it could go on a single-family lot.
I think the intent is, what is the original intent of a shipping container? It was not designed to be a home. Its original intent was a shipping container that is being modified to a home. So I think if someone said, well, the shipping container is on a chassis, but again, you can't take a shipping container and hitch a vehicle to it and pull it. The shipping container has to be placed on an independent trailer and then brought to a job site or some other destination.
Yet we have them in Matunic. as a commercial, right, as a commercial use. Joe?
So my thought on this is we got to be careful not to go student body left, student body right, student body left again, one extreme to the other. There has been, over the last 10, 20 years, there's been a lot of advancements in these manufactured homes. These things look a lot more desirable. They come double wide. But there still is a distinction between them and a stick-built or a modular home. There's still, you can drive down the street and you can see the difference. My feeling is that we are probably too restrictive now to not allow them, only allow them in a certain district, which we're essentially not allowing them. To go into, say, they're the same thing as a single family. You need to take that into context with the other zoning regulations we have. We have a cottage zoning that allows up to, 8 units, or counting the affordable, maybe 10 units per acre. We call these single families. There's nobody stopped to buy 1 acre of land in the middle of wherever, or I guess it would be an R20, and sticking 10 manufactured homes on it, 10 mobile homes on there. And we can't say no because they're mobile homes. We got a comprehensive permit process that allows, if you're doing 25%, allows up to 5 additional units per acre if you get infrastructure. A developer can come in and say, I want to do a comprehensive plan. Your regulation says that these mobile homes are the same as a single family. I'm sticking 6 of these things, or 5 of these things, right in downtown. And guess what? You're accepting it because it's allowed by right. Yeah, maybe I'll do 50% and do whatever that is, 10 units per acre. It's allowed by right by your regulations. So we got to be careful not to go from one extreme to the other. I think that there's been a lot of advancements. I think that we're too restrictive. But to just say that these are the single family and going to be treated the same way for a comprehensive permit or a cottage zoning or even just a R20, because I can't believe people at South County Hills would like a mobile home in one of their lots. And you may say, well, it doesn't make sense to put a mobile home up. But guess what? We don't get to distinguish between it's an old mobile home or a new mobile home. We don't get to distinguish it's a double wide or it's a single. I buy a lot. And you know what? I'm going to build there someday, but in the meanwhile, I got to live somewhere. So I'm going to get this mobile home that somebody's giving away. I'm going to stick it in South County Commons and live there. I mean, and guess what? We have to allow it because it's allowed by right, because we just made that change in our zoning regulations. So I think we just have to be careful again, I think we're too restrictive. I think there's been a lot of advancements. I think there's a need in the community. I think that they can help be part of the affordable housing, but not to the swing of, let's just call these single-family homes and they get all this by right in context with all these other zoning regulations we have. So that's my feeling.
But how would you then proceed? I agree with what you're saying. How would you then proceed?
Well,
what guardrails
Well, we start
or
off by not
mechanisms?
counting them the same thing as a single family. That's the first step. And then the second step is we go through our regulations and say, where are these things acceptable? And maybe open them up a little bit and make it less restrictive than what we currently have. So those are the 2 steps, I think, we need to do.
Robin?
A couple of days ago, I was going down, Ministerial Road, and a prefab house was coming down and wiped out a big branch from a tree and totally splintered the frame that they were transporting. So maybe we don't have room for that type of travel on our roads, especially scenic highways.
So I Googled mobile home, I Googled manufactured home, I Googled modular home, and I Googled trailer home. And on the internets, it's completely interchangeable words. And I Googled trailer home, and there was a picture of a prefab, and I Googled mobile home, and there was a picture of a modular home. I think that we need to make sure that this definition of whatever we're doing is crystal clear. And I think there's, like the whole cannabis, marijuana, pot, weed, whatever the word you use, it's really all the same stuff, but we had different words depending on, I think these words are too interchangeable, and there's way too much confusion among developers and us and town people and town council members, exactly what we're talking about. And, I mean, Jamie just mentioned that it's got a permanent chassis, but it can also come in 2 or more pieces. So if it's got a permanent chassis, but it's coming in 4 pieces, how is that different than just your old-fashioned trailer that is on 1 piece? Like, I'm so confused, I can't make any heads or tails about, and I'm trying so hard to understand the difference between all of these seem to be interchangeable words. And so until, at least for me, I think if there's not a consistent understanding of exactly what we're talking about, it can't move forward with any legislation or regulations, because I think we're all talking about different things. I think if you asked all 6 of us to draw a picture of a modular house, we'd probably have 6 completely different understandings, or maybe it's just me, but I think it's just, I'm so confused about exactly what we're talking about here, or how to differentiate if a developer came in. How can we say, well, no, that's a modular, that's not a manufactured, or that's a prefab, or that's not a trailer? Like, I don't know.
Some approvals were made that there was not going to be any foundation, and then there were foundations put under them. So it's a very vague situation.
So thus the need for some kind of parameters, guardrails with any of this kind of thing, you know?
And as Joe points out, we don't get to judge it on its beauty or its age. So opening a can of worms, we might regret too much. Because if it is a single-family sort of thing, we don't get to talk about aesthetics or buffering or any of the things that we would like to maybe address. If it's a single family and it's being treated like that, we
Versus
have
a
no control.
subdivision.
We have no control.
Madam
Peter?
Chair, the only thing I would add, and I don't disagree that the definitions are confusing. The problem is that the definitions, as of now, have been given to us directly by the General Assembly. So we don't have any room to change the definitions. But, you know, if it's the board's recommendation, you could say, put the definitions in to match what the state law requires, but then don't make any other changes until there's been more study and a better understanding of what the implications are from changing those requirements.
And we still have to worry about transporting them down our scenic rural roads.
So in watching some of the testimony before the town council, I got the impression that our town did not permit anything other than stick-built. That was the sentiment I got from people that were testifying, is that, why is our town only demand stick-built? That's too expensive. Well, that's not what this is, but I think there's just a perception, there's just there's too much confusion about what we're talking about. If some people in town think we only allow stick-built in this town. And that means there's a lot of people who don't really understand what a manufactured home is, or what changes this is.
Because again, as I mentioned earlier, I think the terminology of manufactured home, modular home, and prefabricated home, from a general understanding, is just a home built in a factory. And to Peter's point, the definition state law has put with a manufactured home is consistent with the definition under HUD, with being a home built in a factory on a steel chassis that has an axle. And to, I think it was Susan's point or Maria's, you know, you can buy 2 of these. It'll have a shared roof line, put them together, the ridge vent goes in, and 2 pieces of siding go on, and you have a wider home. You can also, you know, to Liz's point, you can do it, you know, in 4 or 3. And again, they get assembled on the site. The primary difference is that chassis stays with the unit. So if you're putting 2 units together as a manufactured home, they still retain their 2 steel chassis and axle system. Different than a prefabbed home where you would deliver them to a site on a trailer, they get lifted off the trailer and placed on a slab or a foundation. So again, I think to perhaps Peter's point, and I think Joe alluded to it, that this may need a little more clarification from council, working with the planning department on the understanding of the definition of manufactured home, and then potentially under what circumstances the planning board would make a recommendation to council to allow this and where.
And the manner in which we might suggest that, regardless of type of construction, that it's meets the same standards as the, one unit per parcel, and has to, it has to conform to all the dimensional requirements, the zoning ordinance, et cetera.
And I think that we would all agree that if we were to permit them, we would want them to look like a single-family home. It needs to be dressed up in such a way that it doesn't look like it's sitting on wheels, that it's not, that it doesn't look like a temporary structure, that it needs to be somehow skirted or dormered or a front porch built on it or something so that it doesn't look like a mobile home. Or is that acceptable to us, that it looks like a trailer down at Mary Carpenter's?
I don't know if we're there yet. I think it's maybe just following what staff said. Maybe just following what staff said, that we accept the definitions, but as far as the category as to accept it in our zoning as the same as a single family, that we just recognize that although there's been considerable advancements in these, that would still contain a very broad category as far as the style, the age, the condition, and that classifying that as a single-family house could have significant adverse impact to the community when taken in context with our full set of zoning regulations.
Yeah, I agree with you there. And while we're kind of on the subject of smaller units, we need to add to our future conversation to renew the cottage zoning ordinance, because I believe that has expired, right, Jamie?
You are correct, Madam Chair, in March of 2025.
So even though no one has taken advantage of that, it should be an available tool for someone that is interested. But I agree with everything Joe said. I mean, and then when you bring into the whole comp permit and all the other potential, it needs to be well written.
Well, you can have lots that don't have wide roads, so you take some of the hockey stick developments, how would you possibly get that in without ruining the driveway for everyone, right?
Susan?
So before we move on from this, I also would like to point out an inconsistency in the memo that we received. We received a definition of manufactured home on page 2, which specifically says, page 2, on the memo that we received, page 2 says, not the 1 of 8, just the page 2, page 2.
No, you're talking about the attorney's memo.
What other memo is there?
Well, there's the appendix that has the zoning ordinance.
Okay, okay. So in the attorney's memorandum, it has a definition of manufactured home that says, with or without a permanent foundation. At the end of the ordinance, in number 50, which is on page 7, no, sorry, page 5 of 8, it says it's with a permanent foundation. In the middle of number 50.
Yeah, it does.
So I'm not sure which one is the state ruling, and
Oh, turn your mic on.
That number 50 on page 5 of 8 is the state statute. That's the state statute.
Okay,
with a
that,
permanent foundation is the statute?
I suppose it is. So does it say with a permanent foundation? So are you saying that the definition in the statute doesn't match the definition in the ordinance?
Exactly. So the front page of that memo says with or without,
Yep.
and then the definition on page 2 says
1.
with or without.
Yep,
And there's a big difference.
Mm-hmm.
yep.
Okay.
Actually, I'm sorry. Sorry, on page 1, it says on a permanent, oh, wait, never mind. With or without.
To be used as a dwelling with or without a permanent foundation. Okay, and then let's see this.
So Jamie, perhaps you could prepare some better verbiage for definitions specific to also the correct language on the state statute. Have some illustrations for us, because who knows what turned up, especially if you were looking up AI. Right?
That's true. But I think the permanent foundation actually is a pretty critical part of this.
I think part of it too is we can look at the definition too of a permanent foundation, because with improvements of technology, that could differ over time, including today. I think everyone would probably agree tonight, if you're talking about a permanent foundation, you're thinking frost wall, minimum 4 foot, 360 around the unit, and someone permanent may still be 4 piers where it's structurally tied to the ground, but it's not that traditional, 4-sided foundation. So I can have that discussion with legal and the building department.
Right, and it may differ if it's in a coastal, SAMP area.
Right. And Madam Chair, we're just, again, on a short calendar going into July, so I don't want to promise we will have this for your work session. We may have it for your next regularly scheduled meeting.
But you'll have the letter,
Yes.
the Old North Road letter. All right. Before I think we should talk about our schedule and what's coming up, but before we get to that, do we have a volunteer for July 9th TRC? Great, thank you. Morning or afternoon?
Morning,
Okay.
And that is usually Wednesday?
Yes.
Yes.
Excuse me? 9, yes. Jamie, can you talk a little bit about what's coming up, and what did you call it, a short schedule?
Yeah.
What's coming up, and then how we're going to
So our
manage our next work session and joint work session and Able City and all the work that we need to do with regard to that, and where you're at with.
Our next regular scheduled meeting is July 8th. It is scheduled as a work session with regards to form-based code and discussions with Able City East, and the potential for having a joint work session with the town's EDC, Economic Development Commission. They would be available, I believe, on the 8th to Zoom in on the 8th, but they would be available to be here in person on the 22nd. So
You're talking about Able City.
Able City East, yes.
Oh.
So again, I can work with the chair and the chair of both planning and EDC, as well as Jason and Pam King, on their ability to be effective remote or to do something on the 22nd.
Yeah, I mean, we had hoped to have this meeting tonight, and it's been a while since we have seen them, and, an in-person, particularly if it's a joint work session, is always preferable, but also sooner is better than later, because if there is talk about them having a charrette, we have a lot of work to do before then, so, I think sooner would be later if we can manage it.
And there's potential that I can talk to
special
them
meeting.
about doubling up where they're here via Zoom, and then they're here also at your 22nd meeting in a different manner.
Yeah, but what I'm suggesting is seeing if they are available sooner, even if it's a special meeting.
Okay, we can check with that.
And one of the things, this is just a minor thing, but when we have the joint work session, and I'll be happy to come in early to help set up, we need to have the table so that we're all sitting around a table and not the other committees sitting in chairs over there. I think that's,
Yeah, again, we
important
can
for the
look
flow of
at,
conversation.
if the board is willing, we can look at alternative dates the week of the 8th, potentially the July 10th.
okay.
That's a Thursday, be the second Thursday of the month.
I think we should consider it because we really want to get going with this, and
Would planning board members be available that week?
yeah.
Okay, that's fine,
Yeah. It's-
Robin,
it's-
I'm putting you on the spot tonight. We
July
need to
after
know,
the-
we need to know immediately.
We have a meeting on the 8th.
But again, we can send a quick doodle poll out
Yeah, that if we
on
could move it even from the
availability.
8th to the same week, because it's after the 4th holiday, so,
Yeah, the availability of the 9th or 10th.
sure.
Robin and I have wall calendars.
And the
I
intent there
do
would be
too,
to
but-
move our regularly scheduled meeting on the 8th to the 9th or 10th.
Mhm.
Okay.
Yes. So let's see if we can do that, folks. Get them in as soon as possible.
Jamie, are you proposing that as joint with EDC?
Yes.
Okay.
Okay. Jamie, anything else from your department?
Again, we've been working on developing an RFP for affordable housing. We'll potentially add some of that discussion to our next work session. So the planning board understands that we put a proposal forward as a department, working with the town manager's office for South Road School as an example. The RFP contained language to have a minimum of 25% affordable as a baseline, developing a matrix that would give additional points or credit for someone who goes above the 25%. We also looked at parameters of between 60% of AMI and 120% AMI, with more points the lower AMI you go and the more units of AMI you propose. We explained to the council that you kind of have two decisions or tracks to take. The more affordable units you have, the more potential subsidy you need to cover the cost of development. So we're trying to develop a broad spectrum so that we can get significant responses, which then allow the council to evaluate those parameters. You may have a developer who comes in at 70-30, may only, we'll say, require $1 million of assistance, and then you may have another developer who comes in at 50-50 but requires a higher subsidy to cover infrastructure costs. These are things we cannot predict, and we don't know what will bear out in the RFP process, but we're trying to keep options open, but also put a RFP out there that drives a specific product. You spent a lot of resources with Union Studios developing a potential product, a potential density, a potential style, and aesthetic to a home, and we're trying to maintain that throughout the process. Again, not knowing where interest rates will go, construction costs will go, material costs, lending costs. There's a host of factors, and what the infrastructure costs are to the site. Again, our goal is to get well beyond a 25% affordable mix, but again, we have to start somewhere and move from there. So,
And can you send us the RFP so
yes, we
when
can
it
do that.
goes out? Okay.
We will do that.
And do we have any idea of what has happened with the application from the Housing Authority on their project, which I'm sure was
It's
based
my
on
understanding
federal funding?
in the latest round, they were not approved for 9% tax credits. So they are back in the funding realm of looking at alternatives for funding. So again, it's extremely competitive, and there are limited resources. So.
Okay, if there's nothing else, would someone like to make a motion to adjourn? Motion from Robin, second? Joe? Any further discussion? Hearing none, all those in favor say aye. Aye. Meeting adjourned. Thank you, everyone.